Welcome to this edition of Real World Employment Law, where we talk about real-world issues impacting businesses and executives. I'm Declan Leonard. I'm managing partner here at Berenzweig Leonard, and I also head up the firm's employment law practice.
Hi, Declan. I'm Nick Johnson. I'm a partner here at Berenzweig Leonard as well, and I also work in our firm's employment practice.
Nick, we got a great topic here today, a big topic that a lot of companies will be focusing on in 2021. And frankly, I'm expecting you to carry us today on this discussion because you've had nothing but time on your hands. Your beloved Clemson has really just been a non-factor in the championship game. Didn't your brother go to Alabama?
You know, that wound is still fresh, but thanks for rubbing salt in that. You know, it wasn't the best start to 2021 on multiple fronts for that matter. But you know what? We got a good team looking for next year. So
the smack talking that must go on in the Johnson household. Oh my goodness. Well, listen, let's jump into this topic. So when we talk about misclassification, let's bottom line it. What we're really talking about here is, when you have somebody that's working for you, a company, somebody that's working for you, are they an employee or are they an independent contractor? So why are we talking about this now?
Yeah, I mean, I think it's important because, what we find in our practice is businesses struggle with either properly thinking about this or sometimes overlooking this issue of, am I properly classifying my workers? And I think it's important for a couple reasons for businesses to take particular attention to this. What we're seeing on our end is, clearly there is a strong movement on the state level to have these misclassification laws. We've talked about this before on real world employment law about what's going on here in Virginia, how there's a new misclassification law, how here in Virginia there's a presumption that workers are presumed to be employees unless they can meet certain factors. You're seeing many other states pass similar laws that have that same effect. And you're also seeing it on the federal law. Prior to what we're going to be talking about today, there were many different factors that the Department of Labor looked at, that the IRS looked at. There were different federal courts that had different analysis. To be a business owner, it was actually quite confusing to see, okay, what is the standard? What do I need to be looking to figure out, are my workers employees or independent contractors?
And if companies get this wrong, if they end up misclassifying, what's the downside for a company?
Well, so the downside can come on multiple fronts. I mean, I mentioned the new misclassification laws. I mean, here in Virginia, the misclassification law, it provides a private right of action for workers to bring against companies for misclassifying somebody as an independent contractor when they really should have been an employee. It also gets a lot of attention and creates potential exposure under the Fair Labor Standards Act. And so the FLSA, just a quick refresher, that is the federal law that provides for the minimum wage, and it provides overtime for employees that work over 40 hours in a given week, assuming you are non-exempt. Now, what's important about independent contractors are, if you are truly an independent contractor, you are not subject to the Fair Labor Standards Act. And so because of all of that, because of the new private right of actions, because of the potential exposure with overtime and things like that, it's imperative for companies to make sure that they get these classifications right.
And there are some other considerations here. First off, if you classify somebody as an employee versus an independent contractor, companies pay a portion of taxes on behalf of that employee. It's the FICA taxes, and they basically pay their portion of FICA. If it's an independent contractor, you're just paying them straight money. They're filing their own taxes as a 1099, so that's one other aspect. And I think the big one, and we saw this coming out of California with the whole issue of the gig economy and whether or not Uber drivers, things of that nature. If they're independent contractors under the existing law, they're not entitled to benefits. So health insurance, 401k matching, all of that stuff. And so benefits is a big one. And Nick, we've seen this. This is a bit of a tug of war from presidential administration to a presidential administration. So talk a little bit about that. What has been the tension there between when each administration comes in?
Yeah, I mean, these rules I think are constantly changing, and while the rule that we're going to be talking about today is a final rule, the big caveat is obviously there's a new administration coming in. These things are subject to change. The rule does not become effective until March 8th, I believe. And so, these classification rules, they do change from administration to administration. You mentioned, the gig economy. And I think, that was, that particular industry was one of the leading voices for this change. There's a lot of litigation going on across the country, California in particular, over whether Uber and Lyft drivers, whether they're independent contractors or employees. This new rule has been praised by that gig economy for making it just much cleaner, much more business friendly, in simplifying this process. And so let's kind of talk about what these factors are, what this new rule entails. And so the Department of Labor, the rule provides that what you should be looking to in making these determinations would be the economic dependence, and you need to make an economic dependence inquiry. And that basically is an inquiry into 5 factors, 2 of which the Department of Labor has come out and said the 2 are what you should really be focusing on. And so the first
Nick,
2 would
Nick,
be—
real quick, before we jump into the specific factors, just to kind of bottom line it, because there have been so many factors that have been passed over the years for companies to look at. They have simplified it, which is great. But even more so, like the key is whether, as I look at this, the key is whether the individual is in business for themselves, that would put them as an independent contractor, or whether the individual is economically dependent on the employer for their livelihood, whether it's part and parcel of, look, if I'm not working there, if I'm not an employee, if I'm not being controlled day to day, I'm not going to have a living. So let's talk about like the specific factors that you just mentioned.
Yeah, and I think that's a great way to kind of bottom line at what you just said. I mean, because, the factors are, the first one would be, the nature and degree of control the worker has over the work. The more control that worker has, the more likely they're going to kind of tip towards an independent contractor. The second factor is the worker's opportunity for profit and loss. And again, these are the 2 factors that the Department of Labor is focused on and that companies should be really focused on. There are 3 other factors: the amount of skill required, the degree of permanency of the work, and whether the employee's work is part of the integrated unit of production. Those are other factors that factor into the equation, but really it's those first 2, the degree of control and the worker's opportunity for profit and loss.
So let's take those first 2 and let's focus on those for purposes of our discussion today. What are they talking about when you say level of control over the worker? What does that mean in practice?
Yeah, so I mean, I think in practice, things that companies should be thinking about is, okay, am I controlling when my worker works? Am I controlling where my worker works? Am I controlling the specifics of the work that I want this individual to do? Or on the other hand, am I hiring someone because they are an expertise and I am letting them control, however they come up with it, however the sausage is made, it's on them to make it, and they control it. If the worker has that type of control, they're probably going to be an independent contractor under this new regulation.
So an example would be, let's just say for an independent contractor, an example would be you get hired by a company to produce, some kind of a report, some kind of a deliverable where the company basically says, hey, look, here's what I need you to do. Here's ultimately what I want to see in this deliverable, and I need this in, let's say, 2 months. So go have at it, and and keep me apprised from time to time. But you're going to go do the things that you're going to do to get this deliverable. That's going to be pretty clearly an independent contractor, no?
That's right. Yeah, that's right. I mean, I think one example that I see come up is, if you hire a graphics designer or something like that, where you have a general idea, but that's just not your expertise. You want to hire somebody, you give them general guidance on here's what you're looking for, things like that. But in terms of deliverable and what you ultimately come up with, I'm going to leave that to the expert. That's probably going to be an independent contractor.
And then how about the second core factor, which is opportunity for profit or loss based on how much initiative, how much the worker wants to sort of throw into the mix in order to increase their profit from this.
Yeah, I mean, the way that
task.
I mean, the way that I think about this factor is, if you have someone that shows up to work and for whatever reason they just don't have a lot of work, are they going to get paid? When you have employees, maybe it might not be a busy month, and if they're salaried, they're going to come in and they're going to get paid. Whereas if you have an independent contractor who, if they're not working, they're not making profit. Another way to look at it too is, a lot of independent contractors, they, set up, flat fee arrangements where, hey, we're gonna charge you X amount to deliver this product. If the project takes them, longer than they expected, they're losing money on that. And so, that's kind of an example that I think of when I'm analyzing this profit or loss factor.
And the new rule basically says, look, we're not gonna look at a contract that you have, and if it happens to say employment or if it happens to say independent contractor, we're gonna look in practice on a day-to-day basis, how is this relationship being implemented? And so I think that that's important. We've had clients in the past who have said this particular worker has elected to be an independent contractor for whatever reason. It may be that a spouse already has the benefits, already has health insurance benefits, and so being an independent contractor in some ways can maximize the amount of take-home pay for somebody. But I think what the Department of Labor is basically saying is, look, we're not going to look at what a contract says, or we're not going to look at all these theoretical things of how it could be. They're going to look at what's happening on the ground on a day-to-day basis.
I think it's a great point. And while we're not saying you shouldn't paper it, because I think, companies should still paper the relationship and make it very clear, whether the person's an independent contractor or an employee, that fact alone is not going to be dispositive. And I think you hit it on the head. The regulation makes it clear that simply having a agreement that says you're an independent contractor is not going to make you an independent contractor. You actually have to look at these factors, particularly the first two that we talked about.
There's one really big development in here that isn't getting maybe as much attention as I've read sort of the press reports of these new DOL regulations, and that is that now companies can offer benefits to independent contractors. Up until now, that's been kind of unheard of. I guess they could have always done it up until this point as sort of a gift under an independent contractor agreement. Not a gift, but you know what I mean, like voluntarily. But now they can actually offer benefits. And maybe, what do you think? Is that in reaction to what was going on in California and the fight over the gig economy with people like Uber drivers?
I think it could be. That's going to be a very interesting development if you're going to start seeing these, let's just use Uber and Lyft. Are these drivers going to start getting benefits? We talked about how this was praised by the business industry, particularly the gig industry. Because of this, you are seeing, a lot of industries, praise this. And I wouldn't be surprised if the trickle down effect is that you start seeing some of these very, traditional independent contractors get benefits, something that was unheard of, under prior administrations, under prior rules.
Yeah, it sounds like the Department of Labor took a very practical approach here, trying to avoid an all or nothing, almost like a King Solomon approach here by saying, look, one side says independent contractors should be employees because they don't get benefits. And so what they kind of came back with and said, okay, fine. Maybe we don't have to be so inflexible. Independent contractors now can be offered benefits. That's
right. That's exactly right.
Yeah, and so I think it's worth repeating as we wrap this another great discussion up, Nick. It's worth repeating that we're days and frankly even hours away perhaps from the end of this current administration. This was only issued on January 6th. Goes into effect on, what did we say, March 8th? So March 8th. A lot can happen between now and then. I don't know whether or not this in particular will be priority number one for the Biden administration. So these may actually go into effect and govern for part or all of 2021. You can be sure that the Biden Department of Labor is going to take a look at this, and we may be back in these chairs again talking about the newest ones. But in the meantime, good discussion. Thanks everyone for joining us, and have a great day.
Thanks everyone.